Thank you, Mr. Speaker. In the Commonwealth, when someone is arrested, they are then set a bond or a bail. And usually that bond or bail is looked at and based upon multiple issues, one being the type of crime being committed, the other being the past criminal history, and whether or not this person may or may not be a danger to society, or whether or not they will show up in court. Now, back in the 1970s, Kentucky outlawed bail bondsmen in the Commonwealth. But much like everything else, things that happen in other parts of the country eventually make their way to Kentucky. And one of those things is organizations known as bail bond groups. Some are nonprofit, some are for-profit. And they raise money and they use those monies to bail people out who may not have access to funds. And currently in the Commonwealth of Kentucky, we have no regulation for that. And what we've been seeing because of that, Mr. Speaker, is unfortunately some people have been bonded out that should have been remained incarcerated, and we've had citizens, young citizens, teenagers, lost their lives by the individuals that were bonded out. You see, the whole purpose, or part of the purpose, I should say, in bail, that someone come and bail you out, they've got a personal human connection to you. Well, these corporations take away that human connection. And as a matter of fact, just week before last, here in the Commonwealth of Kentucky, we had an assassination attempt on a mayoral candidate in Louisville, Kentucky. The judge looked at the situation, looked at the past, and thought $100,000 was a reasonable bond to set on this individual. Probably, quite frankly, thought that they wouldn't raise that. But lo and behold, a bail project group came along, put up the $100,000. In less than 48 hours, that individual who had tried to take the life of a mayoral candidate in public was back out. I won't say on the street, he still had to wear an ankle bracelet, but nevertheless was released from custody. Now, we all know how easy it is if one wants to cut his ankle bracelets. We've heard testimony over this during the interim. We heard of a family who lost a son from someone who had just been bailed out by one of the bail project groups. He was shot walking home from the hospital. We heard of a young teenage girl just the other day who was driving down the highway, and a guy that just the day before was bailed out by the bail project had committed a robbery, stole a truck, was driving the wrong way down the highway, wrecked and hit and killed this young girl. There is no guardrails. They're indiscriminately going and bailing people out. Now, with that being said, I've had conversations with the National Bail Group, that is a nonprofit, good conversations. I think that their organization is more organized, more thoughtful in the way they go about their approach. But nevertheless, it's still leading to problems. And above all that, we're taking away the judicial discretion of our judges when they're setting these bails. When you have an unlimited amount of funds, you can bond anybody out. So here's what this bill is going to do. This bill is going to place guardrails on these bail bond companies in the Commonwealth of Kentucky. It will limit the amount of bail that they can set on an individual at $5,000. Now, that number is not arbitrary. That number seems to be the most common that they would go to, not the only, but I would say the majority of the cases are $5,000 or less. We want to make sure that people who are in on petty crimes, who are poor, don't have access, we don't want to keep them housed up. We want them to get back out. Maybe some of them have jobs or whatever. But we also want to keep in mind public protection and the safety of the people of the Commonwealth. And so if a judge is setting a higher bond, chances are there's a reason for that higher bond. So we set that limit at $5,000. We're still going to allow them to to utilize their bail funds up to $5,000, except for the offense of domestic violence. Why is that? There needs to be a cooling off period in domestic violence. Sometimes if somebody can get out immediately, they will go back and they will look after or look up or find their victim, and oftentimes it ends in death. So there needs to be a time period there of cooling off for them. Also, it would not apply to a person held under a civil court order of a warrant issued under KRS 22430, which I believe is Macy's law, when people's trying to get help for their family members. They want them to stay there until they can get them in treatment. One of the things we've heard from a mother about the bail group was, I begged and I pleaded with them, stop bailing my daughter out of jail. We're trying to get her help. You keep bailing her. 7 times they bail her out. The family's trying to get help for her, and they keep getting her out of jail. So those are the type of things that's going on. Those are the things we're seeing. This bill would also require photo identification by the individual who comes and delivers the bail. It will require the charitable bail organizations that they shall maintain an annual report and that they shall file that report with the Interim Joint Committee on Judiciary no later than each October 31st. They will make publicly available on their organization's website or by publishing in a newspaper if they don't have a website this information as well. The expenditures of the organization, including separate reporting on the amount furnished for bail or funds or property to serve as bail. In other words, they got to report how much bail and who they're putting it towards, and the number of individuals and classification of offenses that they're bailing out. Now, one of the things that's unique about this bill as well is currently, if you don't show up for court or you violate your bail, the bail money is held by the courts. In this bill, if you are bailed out by a charitable bail organization and you go on and you commit a crime that involves a victim, then the bail money put up by the charitable bail fund will then go to the victim. And for those parents that's lost their lives, monetary can't replace them. Monetary can't replace those lives. But at least it's something. It's something. And with that, Mr. Speaker, I would like to yield to the gentleman from Jefferson 33 for a friendly floor amendment.
Gentleman from McGoffin, I think do you need the committee sub?
I'm sorry, Mr. Speaker, you're right. And what I just gave you was what is House Committee Sub 1, and so I would make a motion for the adoption of House Committee Sub 1.
Motion is for the adoption of House Committee Substitute 1. Is there any discussion?
Have the clerk report, Mr. Speaker. House Committee Sub 1.
Clerk, please report.
House Committee Substitute 1 to House Bill 313.
Motion is for the adoption of House Committee Substitute 1. Is there any discussion on the committee sub? Seeing none, those in favor signify by voting aye. Aye. Those opposed, nay. House Committee Substitute 1 is adopted. Now, gentleman from McGoffin.
Now, Mr. Speaker, I would yield to the gentleman from Jefferson 33 for a friendly floor amendment.
Chair recognizes the gentleman from Jefferson 33.
Madeline Trout was driving on Dixie Highway a year ago today. She had just dropped her brother off, and she was a 17-year-old girl with the Butler High School, and she was killed by a man who Madeline's parents have asked us not to say his name. This man was released on a bond posted by the Bail Project the day before. He had a long history, much of it in another state. Bail Project did not do the proper background check. They didn't make phone calls to connect with his connections to determine who this person is. That's important, right? Why? Gentleman from McGoffin just said, human judgment is important here. There are people in my life, gentleman from Kenton, that I would bail out. There are people in my life, gentleman from Davis, that I wouldn't bail out because I know they're a danger to themselves or they're a danger to the community. But when you remove that human judgment and a corporation is put in its place, That doesn't comport with public safety. So that's why we decided, after 40 years of getting rid of bail bondsmen in Kentucky, that protection was placed by our people that came before us 40 years ago. It's time for another guardrail. And what we've done, as the gentleman from McGoffin said, is we've said that these entities can bail somebody out for non-serious crimes. And so with that, and I'm going to explain it first, but I'm going to call House Floor Amendment 1 in just a moment. I want to tell you what House Floor, well, I guess I'll have it reported, then I'll explain it. Mr. Speaker, I'll ask the clerk to report House Floor Amendment 1.
Clerk, please report.
House Floor Amendment 1 to House Bill 313.
Gentleman from Jefferson.
Thank you, Mr. Speaker. House Floor Amendment 1 makes two changes. The first change is it says that an entity can bail someone out for below $5,000. $5,000 or more, the entity cannot bail the person out. Why $5,000? Well, the gentleman from McGoffin has a lot of experience with this, and we've talked to law enforcement officers. But we also talked to circuit judges, and we asked the circuit judges, can you help us identify what is the number that delineates more serious from less serious? And they did a conversation, a lot of circuit judges, and they came back and they said $5,000 is the number. I thought a different number, but we're relying on more expertise here. So $5,000 or above, the entities cannot bail them out. Anything below $5,000, they can. That's the first thing it changes. The second thing it changes makes sure, because we hear that there's going to be a constitutional challenge, so we made sure that it was extra tight on its constitutionality. So we removed, the gentleman from McGoffin tells you what these organizations have to report annually. They have to report their expenditures, and they have to report what information about the person and the charges the person has that they're releasing. Under the original bill, they also had to report information about their donors. We're removing that for fear that it might violate the First Amendment and we would lose the good of the bill because of that. I want to say the reason we want the information, and we're going to get the information about some of the donors, is because we know that there are taxpayer dollars that are funding the bail project. There are organizations that we fund that say they don't have enough money for their programming, and then they give money to the bail project. So we're going to get to the bottom of that, but to make sure that this bill is constitutional, those are the two changes that this floor amendment makes. So with that, Mr. Speaker, if there are no questions, I would ask for the adoption of House Floor Amendment 1.
Motion is for the adoption of House Floor Amendment 1. Is there any discussion of the amendment? Seeing none, those in favor signify by voting aye. Aye. Those opposed, nay. House Floor Amendment 1 is adopted. Gentleman from McGoffin.
Thank you, Mr. Speaker. That sums up what this does, and if there's no questions, I would move adoption of House Bill 313 as amended by House Committee Sub 1 and House Floor Amendment 1.